How does child custody work in Utah if the parents are not married? Child custody is determined based upon the same statutory factors regardless of whether the parents are divorced or were never married in the first place. Those statutory factors are found at Utah Code Sections 30-3-10, 30-3-10.2, and 30-3-35.2. Those factors are, and some criteria sections are duplicated in other sections, as follows. Section 30-3-10 provides A, evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, the parent, or a household member of the parent. B, the parent's demonstrated understanding of, responsiveness to, and ability to meet the developmental needs of the child, including the child's 1, physical needs, 2, emotional needs, 3, educational needs, 4, medical needs, and 5, any special needs. C, the parent's capacity and willingness to function as a parent, including 1, parenting skills, 2, co-parenting skills, including, in the co-parenting skills, A, ability to appropriately communicate with the other parent, B, ability to encourage the sharing of love and affection, and C, willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. And 3, ability to provide personal care rather than surrogate care. D, in accordance with subsection 10, the past conduct and demonstrated moral character of the parent. E, the emotional stability of the parent. F, the parent's inability to function as a parent because of drug abuse, excessive drinking, or other causes. G, whether the parent has intentionally exposed the child to pornography or material harmful to minors, as material and harmful to minors terms are defined in section 76-10-1201 of the Utah Code. H, the parent's reasons for having relinquished custody or parent time in the past, including 1, duration and depth of desire for custody or parent time. And then, actually that was I, and then we have J, the parent's religious compatibility with the child. K, the parent's financial responsibility. L, the child's interaction and relationship with step-parents, extended family members, or other individuals who may significantly affect the child's best interests. M, who has been the primary caretaker of the child. N, previous parenting arrangements in which the child has been happy and well-adjusted in the home, school, and community. O, the relative benefit of keeping siblings together. P, the stated wishes and concerns of the child, taking into consideration the child's cognitive ability and emotional maturity. Q, the relative strength of the child's bond with the parent, meaning the depth, quality, and nature of the relationship between the parent and the child. And R, any other factor the court finds relevant. But wait, there's more. There's also A, evidence of domestic violence, neglect, physical abuse, sexual abuse, or emotional abuse involving the child, a parent, or a household member of the parent. B, specific or special physical or mental needs of a parent or child, making joint legal custody unreasonable. C, physical distance between the residence of the parents, making joint decision-making impractical in certain circumstances. Or D, any other factor the court considers relevant, including those listed in this section 30-3.10 and section 30-3-10.2. And what's in section 30-3-10.2, you may ask? All right, well, here it is. A, whether the physical, psychological, and emotional needs and development of the child will benefit from joint legal custody or joint physical custody, or both. B, the ability of the parents to give first priority to the welfare of the child and reach shared decisions in the child's best interest. C, co-parenting skills, including 1, ability to appropriately communicate with the other parent, 2, ability to encourage the sharing of love and affection, and 3, willingness to allow frequent and continuous contact between the child and the other parent, except that if the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse, the parent's protective actions may be taken into consideration. As I said before, some of these code sections do overlap. You'll notice one deals with sole custody and the others deal with joint, by the way. D, whether both parents participated in raising the child before the divorce. E, the geographical proximity of the homes of the parents. F, the preference of the child if the child is of sufficient age and capacity to reason so as to form an intelligent preference as to joint legal custody or joint physical custody, or both. G, the maturity of the parents and their willingness and ability to protect the child from conflict that may arise between the parents. H, the past and present ability of the parents to cooperate with each other and make decisions jointly. And I, any other factor the court finds relevant. And finally, section 30-3-35.2, which deals with joint equal custody. A. The court may find the equal parent time schedule described in this section if the court determines 1. The equal parent time schedule is in the child's best interest. 2. Each parent has been actively involved in the child's life. And 3. Each parent can effectively facilitate the equal parent time schedule. B. To determine whether each parent has been actively involved in the child's life, the court shall consider 1. Each parent's demonstrated responsibility in caring for the child. 2. Each parent's involvement in child care. 3. Each parent's presence or volunteer efforts in the child's school and at extracurricular activities. 4. Each parent's assistance with the child's homework. 5. Each parent's involvement in preparation of meals, bath time, and bedtime for the child. I don't know why those specific things made the list and others didn't, but I digress. 6. Each parent's bond with the child. And 7. Any other factor the court considers relevant. C. To determine whether each parent can effectively facilitate the equal parent time schedule, the court shall consider 1. The geographic distance between the residence of each parent and the distance between each residence and the child's school. 2. Each parent's ability to assist with the child's after-school care. 3. The health of the child and each parent, consistent with subsection 30-3-10 sub 6. 4. The flexibility of each parent's employment or other schedule. 5. Each parent's ability to provide appropriate playtime with the child. 6. Each parent's history and ability to implement a flexible schedule for the child. 7. Physical facilities of each parent's residence. And 8. Any other factor the court considers relevant.